I hope everybody's had a amazing summer. We didn't do one last month. Tony was going to do last month and had something come up, so we moved it to this week. And then I'm looking at either September 11th or September 18th to start back up weekly. So we'll see which one of those work out. And then Wisdom Wednesdays, we're going to start September 13th as well. So those will all be getting ready to go next month.
What book are we going to review?
He was Trent wanted to do because so many things came up during evidence and procedures. We were going to do Waddles, one because it was a little bit shorter book, but there was so much that referenced on evidence when it talked about legal descriptions and writings and interpretations and that kind of stuff that all correlated back to kind of the Waddles book. So we thought we'd run that one and get through that one maybe in a couple months or something like that. But I do notice even when I sent out the email on Friday, there's still everybody on those last minute vacations before summer ends. So it's been
all the kids are going back to school. Everyone's busy. I don't know when the school is back some places, but it's this week. So everyone's scrambling.
Yeah. Las Vegas was last week. So they're all over, all different times of the year for sure. So, well, let me, I know you only wanted a couple sentences as always. So I will, let's see. I got the first one. We'll go with the second paragraph and we'll get started. Tony is a licensed attorney, professional surveyor and mapper, PSM, in Florida, and a registered professional land surveyor in Texas. Holds a PhD in geomatics, a JD, a law degree, a MS in geospatial surveying and engineering, and a BS in surveying engineering. And Tony can be contacted at cnettleman.net or what's your other one? The
NLC Prep.
Yeah, NLC Prep. Good Lord, I totally blanked out. So good save there. So this was Tony after Jeff did his presentation. Tony says, I want to do one based on Tony's view. And so tonight's a quasi-judicial from Tony's view. I love it. He wasn't doing a PowerPoint. It's all going to be just conversation. So hopefully we can get everybody to kind of chime in and add to the conversation. So I will.
Yeah, that'll be great. Yeah, so exactly. First of all, welcome everybody. I'm really glad you're here. I'm going to change. Does that sound better?
Mm-hmm.
Okay, good.
It's better.
Welcome everybody. I'm glad you're really here. This is exciting. First of all, I want to thank Trent for doing these. These are really interesting mentoring Mondays. I mean, rarely has anyone ever set up a CEU weekly, monthly show for absolutely no benefit to himself. So if you take a second and thank Trent, it's a big deal.
Thanks.
I was in Canada a few weeks ago, and I met this guy who runs Wolford College. I don't know if that's the correct spelling, but he does just like this in Canada. He described Mentoring Mondays, and in the Canadian version, it was weird. And it's not a college. It's just a group of people come online every week and one person does a presentation. I had to laugh. But Trent, thank you for doing this. We appreciate it, first of all.
Thank you.
So, the reason why I decided to run this presentation is because I went to Idaho last month to go backcountry flying for a week, which was super cool. And I was bored on the airplane. It was just a unpleasant flight back, we'll say. And I was bored, so I bought the $5 for the internet, and I watched some Mentoring Mondays. Watched the business one that Landon did. Watched some other ones, and I think Jeff Lucas, his was the newest. So I watched it, and I swear, like 75% of it, I was nodding my head in agreement. A lot of people think that, Jeff is kind of untraditional, but a lot of the stuff he said was right from the Browns and evidence procedure from Clark. So, and I really like Jeff. I see him a few times a year, in different conferences. I saw him in Palm Beach recently for a court proceeding. And I think Jeff has a really good grasp of the legal aspects of surveying. I agree with a lot of what he said. But in like the last 25% of the presentation, I was like, no, 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 no. So I was laughing and I said, I should email Trent and ask him to come on Mentoring Mondays. And I'm going to rewrite the quasi-judicial functions of a land surveyor. I'm going to, write my version of it and present it on Mentoring Mondays as kind of a joke, but kind of not a joke, when it's funny, not funny. So I want to thank you guys for being here and, start off with this fundamental concept that there is really binding law, there's persuasive law, and there's no law at all. So binding law means you have to follow it. You're a Nevada surveyor and there's a Nevada Supreme Court case which lists out the priority of calls. You better follow it or have a really good reason not to follow it, like a weird, situation. Otherwise, going to be in big trouble if your work is disputed. And I'm watching all the comments. So if you guys have any comments or want to chime in, just turn on your mic and say something. Now, there's another kind of law called persuasive law. Now, persuasive law is, you're in Georgia and you can't find a good Georgia case. So you go looking for cases or for textbooks or something else, and you find it in Florida. Well, can you use that? Sure, you can. You're not required to use it because it's not in your jurisdiction, but you can use it for sure. If it makes sense, if you can back it up, use it. Now, the third kind of law is no law at all. When you basically make up your own rules, it's not in a textbook, it's not in the court case, it's not in a statute, whatever, then it's no law. And I should mention that the board acts and the board rules for your home state, that's binding law. The rules say you got to renew your CEUs every 2 years. You better do it. Otherwise, they're going to yank your license. So stuff you have to follow. Now, the quasi-judicial function of a land surveyor, it's been put as an appendix to evidence and procedure, which is awesome. And I'm going to copy out the appendix here in the chat window if you want to pull it up. But, the quasi-judicial functions of a land surveyor was simply a private person writing a paper for a continuing education deal, right? It was a conference. The judge wrote a paper. Now, he was a judge in the Michigan Supreme Court, but this was not in a ruling or anything. This was just a paper he wrote about his experiences with land surveyors. And it's so interesting because if you read this, it's a little bit long, but if you read it, it talks about how original evidence is sacrosanct, how if you don't have any evidence left, you got to go to possession. Okay. And sometimes possession does not match your original monuments. Agreed. And how to deal with this evidence you find. You got to, every time you find evidence, you have to weigh it against the other evidence. And you better have, a preponderance or more likely than not of where the boundary is. Otherwise, it's not going to be defendable. So all this stuff we've heard in the textbooks and court cases, this is really good, a summarization of how land surveying works. It's great. And but this paper is not binding on anybody. It may have been referenced in a few court cases or other things, but it's just an interesting paper presented to a group of surveyors and lawyers. And you don't have to follow anything it says. It's not binding law. Now, moving on from the fundamental concept, I feel like we've got two different schools of thought, from the Clark and the Browns and evidence and procedure. You've got this idea that the surveyor is not Jeff Lucas calls him a deed staker, right? You're not here to provide, positive determinations of property. You're just here to locate the evidence and interpret the evidence and come up with a boundary, but it may or may not be the property boundary. Then you've got the more, I call that the traditional view. And then you've got the contemporary view of Jeff Lucas, where you guys are out there weighing unwritten rights and making property determinations and doing all this other stuff, right? So traditional and contemporary, we've got kind of a rift between the two schools of thought, which is kind of fun because it gets a good debate going between the community, and you guys get to decide, do you go the traditional route? Do you go the contemporary route? Or do you go somewhere in the middle? It's your choice, right? And I thought it would be fun to compare these two schools of thought and talk about, kind of what I think about the two and how I practice my boundary surveying, because I'm always relocating boundaries all the time. Crazy stuff happens. And as a funny story, I did a survey with Trent, and we realized that the client got exactly what they wanted, but there was a 20-foot of the backyard which was actually on the golf course. So the client had no idea that there was this huge problem in the backyard. He was concerned with the side yard. So the side yard was all good, but the backyard is a complete mess. So it's always fun giving the clients, what they want, plus an Easter egg that they had no idea what was hiding behind their property. So, okay, so we talked about the fundamental concepts. We talked about the two schools of thought. Now we can talk about, this idea of deed staker versus property surveyor. You know, from what it's been a few months since I watched Jeff's presentation, but it's my understanding that, Jeff goes to the original documents, he does the boundary retracement, just like I do, but he also looks for encroachments, evidence of possession, like fences or walls or, hedge lines, same thing I do, no different. But from what I understand from the contemporary view is that Jeff believes that you can show a property line through unwritten rights based on the found possession, like the found encroachments. Is that right, or am I listening? Did I hear that wrong?
No, you heard that right. Yeah.
Okay.
Yep.
So I think this is kind of a false dichotomy, because really, I and Jeff are doing the same process, right? You do your record research stage 1, you do your field work stage 2, you weigh the evidence in record title versus field evidence in stage 3, you produce a map and a report. I mean, basically, those are the 3 steps of a boundary retracement survey as I do it. Now, what happens when Jeff finds that the wall is 1 foot in on the other property? So there's a 1 foot by the whole property line encroachment. It sounds like Jeff moves the boundary 1 foot to match the possession if there's enough evidence of the possession. It's been there for a long time, or, whatever criteria he does. Is that right?
That's a good question. I don't recall.
Yeah, I'm not, from my understanding,
that.
that's what he does.
Yeah.
Now, what I do myself is that I will document the record line, where is the monuments and, what is from the land title. And I will also show any encroachments or potential encroachments, or basically any structures along the boundary, a pool, a walkway, a fence, who knows what, a bridge. We kind of all kinds of crazy stuff. I even survey in the hedge lines and the trees and stuff too, laser scan it all, put it all on the map just to be safe. But I'm not willing to give any property or show any boundaries just because of possession. Now, I'll collect the evidence and I'll tell the attorneys to go sue each other, and the judge can decide whether this has been unwritten rights or not. But I'm not going to make unwritten rights determination to move the boundary. So that's my, difference between the contemporary versus the traditional in a nutshell. So how I kind of think of this is that the surveyor is really a collector of evidence. You know, we're a collector of deeds, of easements, of leases, and I put all that together before I ever go to the field and I make a working sketch. And the working sketch is basically a survey sketch with all the deeds pieced together as a mosaic, any easements overlaid, any leases, whatever I can find. And, you know, the scary part is even just analyzing the record title, you find weird stuff, overlaps, gaps, um, you know, or it may look great. Like there's a beautiful, you know, quarter section of land and there's an easement running along the top of the quarter section, the north 50 feet, and it looks really clean. Well, then you go on to step two and you go out there and you find the survey monuments, you find the section corners, you find the monuments that have been put in by resurveyors, and you're searching for this field evidence that connects the deeds to the physical property. So they called for a 5/8 inch cap with PLS number on the deed. You go find the cap, and whammo, you've just, you know, run this like thread from the stage one to stage two. On top of that, I'm not only looking for field evidence in terms of monuments, but I'm also looking for any improvements. So the structures, the routes like the roads, the, you know, gravel driveways, all that stuff, the fences. And I usually like to do that with a combination of traditional instruments like RTK and total station. I always fly the property with a drone or a fixed wing airplane. And I've really gotten to the point where I laser scan everything too, because you never know what you want to pick up in the field. So I'll LiDAR scan everything, every property. You know, if I'm doing 2 properties, I'll survey the 2 properties and all the adjoiners around the 2 properties, and I'll LiDAR scan everything. So now you've collected a ton of field data. This is exactly what Jeff is doing, I think. I'm not sure if he's flying it or collecting LiDAR, but he's definitely picking up the improvements, potential encroachments, all that stuff. So, you know, I understand what he's doing and I agree with it. But what I feel like our job is as surveyors is collecting all this evidence and then interpreting it based on a strict set of rules of evidence. And I'll come to what that means in a minute. Now, on the other hand, I feel like, you know, Jeff's presentation was really putting the surveyor in this role of judge, not a quasi-judicial judge, but a judicial judge. Like you become the decider of evidence. You know, does this fence meet adverse possession, acquiescence, latches? You as the surveyor are weighing this evidence saying, yes, I think that the fence does form a boundary line by agreement, but I don't think the other wall on the other side of the property does, because it just got built 3 years ago. So, you know, Jeff has taken this one step further where he is becoming kind of the judge and deciding, you know, unwritten rights based on some set of laws. Now, what do you guys think? What are the dangers of doing this?
That's a good one for Stahl. If he wants to unmute himself. Yeah, there you go.
Yeah,
So what do you think, John? You know, you find a wall that's encroaching by a foot.
My first comment is you've greatly oversimplified the role that Jeff has taken.
Okay, tell me.
You don't jump to what you're referring to as unwritten rights as a solution to every problem. And when you look at it from a legal perspective, there is no such thing as unwritten rights. You can search every case in the entire United States for the term unwritten rights. You will find 0 cases that define what an unwritten right is. It's a surveyor's lingo that's talking about certain doctrines that say, here's how you determine a boundary line. A boundary being the demarcation of ownership between parcel A and parcel B. That's a boundary. Bottom line, simple. But we try to overcomplicate that when we start looking at, okay, we've got this doctrine and this set of evidence and this, these boxes to check, that I can say now the boundary is here because of this particular doctrine. Or in this other fact situation, the boundary is here because of a certain set of doctrines or check boxes. But each one of them has a specific set of requirements, and those requirements exist for every boundary we ever survey anywhere. And so every time you say, yeah, in my professional opinion, here's where your boundary is, it's a result of the evidence, the rule of law applied to the evidence determines the facts, and the facts apply to the rule of law, which determine the outcome. And that is, where's my boundary? So it's a definitive process, an evaluative process that we have to go to or through. And there are the simple doctrines. Yeah, boundary, it's a call for a monument controls over course and distance. That's in one of the doctrines. And we do it all the time. We don't even think about it. But then we get into these ooh la la scary ones like unwritten rights, we try to call them, but they're not. They're just more doctrines that are define boundaries. And we get all uptight about, well, I can survey those kind of boundaries, but not these kind of boundaries. I can express my professional opinion in this setting, this boundary setting, but I cannot express my professional opinion in this boundary setting. And I think that's where we start getting this dichotomy of push and pull, and not really certain what we can and cannot do as surveyors.
So set me straight on, you watched the Jeff's presentation. I'm sure you've read his book. So, I mean, how far is the Lucas doctrine willing to go on, determining boundaries that are either inconsistent with the original monuments or resurveyed monuments, or when there are no monuments?
Well, yeah, and when there are no monuments, now you're saying, okay, there's no physical evidence to tell us where the boundaries are, right? No
Right. Yep.
surveys, no prior surveys, or all you've got is a legal description, say.
Yep.
Okay, then you've got a set of evidence that's going to say that the only thing controlling in that situation is the written description. And so the deed is going to be paramount. And that's where we get into, oh gosh, Four Corners doctrine, the deed is the only thing that matters. Well, in that specific situation, yes. But
what if there's a fence
other times
that's built over so you go survey the deed boundaries and the possession does not match the deed boundaries? What would Jeff do? WWJD.
Well, you could do that with John too. WWJD.
Yeah, there you go. What would John do?
Yeah. If the occupation doesn't match the deed, well, then the question is, well, why? Who did what, why, when, and why it doesn't it? Because it should. I mean, people should know where their boundaries are and build fences on them, right? And so, was the fence intentionally built a foot off the line, like some do? Well, then the fence is great evidence is to measure over a foot, and you'll find out where the boundary is.
But how do you know if it was built over a foot by the line? Like, how do you know the intent of the fence builder?
Others fences, and you have to gather more evidence, and you have to dive deeper. You have to actually talk to people, prior landowners who built the fence.
Well, say they're dead.
Did you know where the boundary was when you said it? Did you have a survey at the time? That's called investigation and gathering evidence, and it's evidence that's absolutely necessary to determine where the boundary is.
Yep. Yeah, and I agree with Lynn. I agree with Lynn, who says find the best available evidence. But not only should you find it, but once you find it, so this is stage 3. So stage 3 is taking the record, taking the field evidence and coming to a single determination. You're going to draw a map,
Trying to, yeah.
and you don't get to make two versions. Like I've seen maps where surveyors have two different lines
Oh, yeah.
for the
I've
same
seen
boundary.
several different lines, and it's like, well, where's the boundary?
Mr. Schroeder, yeah, come on, jump in. You don't-
Identify the problems, but we're afraid to apply the appropriate rule of law that's designed to resolve the problem.
Yes,
Here's where we've got a potential of a boundary here, potential there, possible over here. Well, which one is it?
I
The
agree
rule
with
of
you,
law
John.
will tell us.
Yep, I agree with you, John. I just think that we have a certain rules of evidence we can use, like priority of calls, junior senior rights. All these things are rules of evidence. But what happens when the rules of evidence we have, the traditional rules, don't solve the problem? How far can we go out,
Mhm.
outside of our traditional rules?
Yeah, there are a few
Mike
cases
Schroeder.
that address that. There are a few cases that have become novel cases, de novos, that where they will actually come up with a good reason. I was doing a presentation, I believe it was in Minnesota. They had a case where there just was not a solution in their law for that particular problem. And so
And what do you
said,
do?
okay, here's the answer. The judge came up with an answer and said, this is the best I can do. Well, they appealed it, and the appellate court looked at it and says, yeah, best you can do, and agreed with it and upheld the decision. So
Yes.
yeah, sometimes that's all you're left with is the best you can do. And nobody will fault the professional for doing that.
But I think that if you don't have enough evidence to come to a positive boundary determination, you need to tell your client you don't know. There's not enough evidence, and because the farther you put yourself out on the plank, the farther you stretch the evidence to match what you think is your opinion, the more dangerous it gets.
Oh yeah.
And I've had a lot of times where I'll tell the client, look, there's not enough evidence to determine where this easement is or where your boundary is. You need to either sue your neighbor or make a boundary line agreement and settle this or go to court, because I cannot give you an answer beyond a preponderance, and I'm not going to give you an answer I can't defend.
Yeah, definitely. There are surveys and there are boundaries that the ambiguities are just too great. There's too much ambiguity for a surveyor to resolve. So then it's therefore the only solution is for the landowners to get together to fix it.
Yep.
And that's the best solution and I do that all the time. Sit down with the landowners around a kitchen table and hammer it out and say, hey, here's the problem. Yeah, I got evidence that says you're right. I got evidence that says you're right. I've got evidence that says you're both wrong. Doesn't matter.
I've never met property owners that are that.
The landowners own the land. They can fix it. They're the only ones who can fix it. And so I will encourage them through mediation to just resolve it, get a boundary agreement, document the agreement. Now I can finish my survey and say, there's where the boundary is. With 100% certainty.
You got.
Thank you, John. Michael.
Yeah, I was gonna say you got three hands up.
Okay.
So I'd have to overall kind of agree with what Tony's approach is. In my private surveying experience, which is most of my career, I never, I guess, monumented what I would call an altered boundary due to, and I just use the catchphrase unwritten rights because may be perfectly correct, although I have documented it and brought parties together and executed boundary agreements. My biggest problem with it is on a couple folds. One is, you break the chain of record, whether it's a deed or a plat, a prior record of boundary survey of properties. Let's just say the two lots are 100 foot wide, and then suddenly your survey based on this evidence of a fence or an encroachment, you've got one 99 feet and one 101. And that's if everything's in the record. And so, and how well has each of these surveyors, if this goes over time and say these properties have been resurveyed, 5 times in the last 50 years, where's the evidence for those decisions? And if you're in a non-recording state, even if it's in some file, I mean, What's the due diligence of the modern surveyor that goes out there and says, how did this change? It was done in 1967. There are 100-foot lots, and suddenly I found an unrecorded surveyor from Surveyor Smith, and it's 99 feet and 101 feet. And there's no, his rationale, his interpretation of being a quasi-judicial judge out there, of there's some doctrine that is applied to warrant him to move the boundary line to I guess equidate the situation. This could just be a nightmare as time goes on. And even if they're in the records, I think a lot of our governmental agencies, a county, a state, or whatever, are just going to question, how come these 200-foot lots suddenly went to 101 feet just to satisfy some doctrine. Now, on the same hand, if you can't determine where the boundary line is based on the normal hierarchy calls of monumentation and deed description or plat information, and that is the only evidence you have out there, maybe, is possession. That was the way I was taught. Well, then you start looking, you start doing those interviews, you try to find the guy that built the fence, you try to find prior owners. Oh yeah, we built that fence and that corner was there, I dug it up and put the fence post out. That type of evidence, I'm fine then, but it's going to be documented on the survey, and hopefully we're a recording state, so recorded how you determine the corner position. So that's probably enough feed there, and I'll just kind of quiet down now and let others chime
Yeah,
in.
thank you. That's great. And it's funny you said that, what was the intent of the parties? And I have a case in Palm Beach where a gentleman in the 70s built a fence that was a few feet, inside of his boundary. And now his neighbor has come in, he got very elderly, neighbor came in, built a larger house, built a pool, all this stuff. And we asked him, why'd you build this fence? He said, well, I had young kids and I didn't want the kids to get near the ocean. This is a waterfront lot. Well, did you know where your boundary was when you built the fence? Had no idea. I don't care. I'm just building the fence to save my kids. So it's interesting, can a non-boundary fence ripen into a boundary? Maybe, but I'm not going to make that determination, because I'll document the fence, I'll document the monuments, I'll document the pool, but I'm not going to tell you that your boundaries moved by 3 feet based on eyewitness testimony, or not. I love this. We've thrown a hand grenade into the mentoring
Yes,
Mondays.
yes.
We have 3
Oh,
people
yeah.
lined up.
Go,
All right, let's just go
Jerry.
down the line here.
Yeah, it was
You wanna-
Jerry, and then Connie, and then Rob.
Okay.
Jerry.
Um,
I love it.
yeah, this is a real interesting area because, every state has got some sort of statutes that address adverse possession, which we know is how ownership can change based on action between adjacent parties over time. Certain conditions have to be met. But by the same token, we can have oral agreements between parties to fix boundary lines. By its very nature, that's an unwritten transfer of land between parties. Different states have different requirements for that, but I can give you case law in Wisconsin that goes back 150 years to identify what the requirements are for oral agreements. And you go on there, you can find the property, you can locate the corners, they'll be buried. But the adjacent owners didn't dig to find the corners. They just said, well, let's run it between the tree line here and the seam in the sidewalk up there, and let's put up the fence. So they make that agreement. That agreement, who's that binding on? Because if somebody goes and checks what's in the written record is constructive notice of what those people had title to. The fact that they made an agreement, now you've got an unwritten right situation, some rates of exchange. Equitable estoppel is along those same lines also. You can't tell a lie today, you can't tell the truth today to benefit from a lie told yesterday. That's another form of ownership that can change hands based on actions of parties. So anything, you might not search for and find unwritten rights as a doctrine anywhere in case law, But the actions that people do result in rights that ripen that are not in written form. That's the whole basis. You have written rights, which is the deed and the description. That's what's constructive notices is when you record the stuff. And then you have the actions of the party, which causes the deed line and that ownership line to separate over time. And the question then is, and this I think is where the dilemma is, what is a surveyor's responsibility with respect to deciding what the ownership status is of the land? And at a certain point, again, you're crossing over into that judicial function as opposed to strictly the finder of facts and evidence and trying to make a decision based on that. There's no clean answer to it. And I think that Jeff's contention was that the term unwritten rights came from Curtis Brown not having anything else to call this stuff, so we just called it unwritten rights as a category. And I think that's kind of a neat bucket to dump a lot of these dilemmas into.
Yes.
That's where they arise from.
Absolutely.
And they are great buckets. I love that because I sit down with attorneys a lot of the time. I talked to 5 attorneys today about their land disputes. And we talk about, 2 buckets. That's exactly what Jerry said. The written rights, what's in the land title, the unwritten rights, all of these different, what they are in law is affirmative defenses, latches, estoppel, acquiescence, boundary by agreement, adverse possession, prescription. And the surveyor has made a giant bucket and he puts all his affirmative defenses in one bucket and says, well, your written rights are that you own 100-foot by a 50-foot parcel, and here it is. Now, here's your problem. You built $2 million worth of fiber cable 2 feet over your boundary, and it's been there for 30 years. Well, is it your property? No, it's not. Do you get to keep your cables, or do you have to tear up $2 million worth of cables 35 years later because a new neighbor just purchased? Is that fair? No, it's not fair. So I'm not going to move your boundary for you. I'm going to give you a survey with a survey map of the fiber cable, the fence, everything else. You go to court and you tell the judge, hey, this isn't fair. I've had this cable here for 35 years. It's not fair. And the judge says, you're right. Equity is not in your new neighbor's favor. And it's funny that when this new neighbor purchased their lot, there was an explicit exception to their title policy saying there were serious problems along this boundary line and had been in a dispute for, 5 deeds prior. So they're not going to give you title insurance to this 30-foot area. Well, should the neighbor have been on notice that there was a real problem before they bought this huge parcel? Yes, and they still bought it. So is it fair if the neighbor had notice prior to buying the property there was a boundary problem? They bought it for fair value, and now they're suing the telecommunications company for millions to move their fiber cable. Is that fair? No, it's not. So, maybe I'm oversimplifying it, but I feel like Jeff would want to make a judicial determination that the boundary had moved because it'd been used for 35 years. Whereas I feel like we as surveyors are just collectors of evidence. We'll document the dimensions from the record boundary monuments over to the fiber cable. But I'm not going to give you 2 feet of land because you had the cable here.
So as an expert witness in that case, and the judge asks you, so in your expert opinion, where's the boundary?
I'll tell him the deed boundary is 50 feet by 100, and there's 4 monuments which I found that document this boundary. So I'll tell him the fiber cable
could be there.
No, I'm going to give him one answer. The fiber cable is 1.5 feet over the deed boundary line to the south, and it gets farther and farther away up to 5 feet to the north. So I'm going to tell him where the boundary is, and I'm going to tell him the fiber cable is on the neighbor's property.
Yeah.
And then I'm going to,
you're stating facts.
yeah, exactly. Just
Mhm.
facts. And I'm going to say, you know, I looked at the aerial imagery, looked at the satellite photography. I see where they built the fence 32 years ago. And in my expert report, I'm going to have witness statement from the telecommunications employees saying, I started work here in 1986 and I watched them build the fence and the fence hasn't moved and I watched them dig the hole. So I'm going to give them evidence as to when the encroachment or potential encroachment started. I'm going to give them satellite photos to show when the fence was built, but I'm not going to tell them the boundary moved by 2.5 feet because they built the cable. Connie, you've been waiting too long. Tell us your thoughts.
Well, so there's two things we're talking about over here, and I'm gonna address that, and then I'm gonna backtrack to something that I wanted to initially bring up. So the two things that we're talking about is that a surveyor needs to be very aware at what their non-negotiables are. For example, certain things that we like to call unwritten rights are actually things like adverse possession that need to be adjudicated. They're not up to the surveyor to decide if adverse possession has occurred. Surveyor might uncover evidence of possible adverse possession, and you will probably don't even want to write on your survey a suggestion that this is an adverse possession. Just state the facts to show the evidence. However, when we go back to things that the surveyor can do, and this is, I think, where the confusion was starting with, I watched Jeff's presentation. I don't remember it in detail, but I never got out of him that he is advocating that the surveyor starts going into the territory of practicing law or deciding, making decisions which really need to be adjudicated. However, when you're analyzing a boundary, you can often run into conflicting evidence, which is purely survey evidence. You could have conflict in records. You can have, well, let me back up on that one. So having made that statement, the way I approach usually, I look at all of my evidence, entire body of evidence. I set up the evidence hierarchy so I know the strength of, so I know where in the hierarchy that evidence, how much weight it bears. Then I looked at each piece of evidence to see how strong is that piece of evidence. For example, everybody says monument is the strongest evidence. However, if this is a 4th generation monument that is maybe not properly documented, that's not necessarily a strong monument, even though it's a monument. So once I set up the strength of evidence and the hierarchy altogether into my entire body of evidence, then I look at what the non-negotiables are. Anything that needs to be adjudicated, I'm not going to make a decision on. That's going to get passed on to the owner, and I might suggest that they need an attorney or talk to a title company or whatever the case may be. Now I'm left with having to make a decision on my body of evidence that is within the realm of what a surveyor is allowed to opine on. And this is where you're looking at, do I have preponderance of evidence to make a certain decision? So, for example, let's talk about fences. There are situations, let's say fences from 1960s or 1970s. In a tract, you can actually pull up a street improvement plan or a site improvement plan, and you can tell that that particular improvement plan and all the improvements that were built at a time are all original improvements, which were the intent of the subdivision. So let's say monuments got knocked out. The rest of the construction, you can tell by the improvement plans and the entire body of evidence that it is actually your best available evidence of the intent of that subdivision. In this case, you can hold the improvements as your best evidence, and you can make a decision saying, well, you know, in most, you know, if there's a little bit of shift, you can decide to hold the improvements as opposed to maybe shifting a monument location, not the monument location, but shifting lot line location by 1/2 foot so that all of a sudden you have walls that are out of place. I'm going to hold the walls rather than just prorating through the tract and creating conflict where I already have evidence there shouldn't be any conflict. And also I'm gonna weigh that on my total body of evidence, and I'm gonna have to figure out, in my own opinions, where is my comfort level? How close is this evidence to being even to my contrary evidence? Do I want to take that risk? Do I want, how much how much is my insurance going to balk at certain decisions? I want to be in a relatively safe zone to where I can document and present my evidence to the level where most other surveyors going to agree with. If something is
Yes,
too
that's great.
controversial, I may need to bring it up to the client and the rest of the parties saying, look, there are issues which are beyond my ability to explain and document. So in essence, we possibly have an unknown location of the boundary. So there are remedies for that, possibly a boundary line agreement, or if it's something more complicated, it may have to be adjudicated.
That's great. I like, Connie, how you say your level of comfort, because, if you are really certain of something, put it on the map and hit go. If you are pretty certain of something, put it on your map. But I really feel like every boundary relocation survey should require a report. What record data did you get? What field evidence did you find? How did you make these determinations? Like, what rules did you follow? Did you have to apply the priority of calls on 2 monuments? Did you have to reject a monument because was not a record dignity monument, like it wasn't called for in a deed? And if you get to the point where you're feeling uncomfortable, I always ask myself, I expect every survey I do to go to court, every single one of them to go to the judge. And I say, can another surveyor do more record research and contradict my findings? Legitimate. Can another surveyor do more field work and legitimately find more evidence than I did? Is my survey open to collateral attack, or have I done everything in my power to come to a true determination? And if I don't have enough facts to make that, not like a preponderance, that's 51%. I mean, I want to be like 95%, 99% sure. If I can't provide certainty, I don't make the survey map. I just make the report and I say, look, here's the evidence. It's conflicting. There are major issues here. Go make an agreement. And I'll even draft your boundary line agreement for you. If you guys want to tell me where your line you want it to be, I'll write you a legal description for your property. I'll write you a legal description for your neighbor's property. We'll sign an agreement. We'll go to court and get a stipulation or a final order, whatever they want. And you can use my legal descriptions to settle this. But if I don't feel comfortable, like 95% comfortable, I don't do a survey, because I'm not going to jeopardize my license or my liability or my reputation on something that another surveyor could contradict. So yeah, that's a great point, Connie. Now, Rob, I know you had your hand up. You want to say something?
Yeah, one of my questions was, I think you kind of hit on it, and I think John may have hit on it also, is when you come up with your client and the adjoiner come up with the agreement.
Yep.
Maybe you mediate that agreement and you come up with that. The question that popped into my head was, in non-recording states for the survey, you would still do some kind of exchange of deeds.
Yeah, absolutely.
And file those deeds, but those are going to be a paper deed, whatever, an actual physical transfer of title, because you'd otherwise be, would you otherwise be in jeopardy of violating statute of frauds trying to do land transfers without that?
Oh, it has to be in writing. Yeah. So, typically what I would do is I would tell them to file a friendly lawsuit, file it in district court, make a final, come to a stipulated agreement, and let's record in the agreement both legal descriptions. Now, take that agreement, go to the clerk and record it in the property records on both the properties as well. So now you have it in the court records. Now you have it in the property records. So there has to be a recording, because even if it's not legally required, you've got to get this in the record, because what if there's a boundary line agreement that wasn't recorded, not in the public record? What a nightmare. What a nightmare. And I just had a property case in Orlando where there was 4 or 5 parcels that were split. So it was one big parcel split into 5. And when they wrote the deeds, they were good. But over the past 75 years, they've slightly modified the legal descriptions, like the bearings changed a few degrees, the distance changed a few feet. Well, guess what? There was a boundary line agreement between these 2 properties that described it using palm trees, and the palm trees are still there. So even if the current titles are a little jumbled and don't quite fit together, let's go back to the 1950 boundary line agreement that cut these 2 properties. It's in the public record, it's in the property record, and in the district court, found at both places, done. And that's why you record these BLAs, because they can become useful, decades later. So definitely get it recorded. All right. I love these discussions.
Yeah, Jerry's got a good comment in the
What did you say, Jerry? Let's see. The question is, whom is the oral agreement binding on? Just the original parties? Oh, on all the subsequent parties. Yeah, definitely. You make the agreement, you change your boundary line today, it's going to be binding forever.
No, not with an oral agreement. An oral agreement.
No. Boundary line agreement is the written agreement.
Yeah, written agreement you're binding, but oral agreement is only binding on the parties and subsequent purchasers if they've been informed of the agreement.
Well, no one should be doing a boundary line agreement orally.
Well, yeah, I've run across several actually.
Well, no one should be doing it.
It's like, well, let's get this thing documented so we can make it binding.
No, but that's what I'm getting at, is maybe that when you're dealing with a property, you're reading a resurvey, and that fence is there because of an oral agreement, but it wasn't the current parties that were
okay. So this was an oral boundary line agreement.
Before. Yeah, not in written. That's what I'm getting at, is with the oral agreement. It's like the unwritten aspect of it. It's not documented. If you're outside the agreement, are you aware of it?
Well, here's what I would say is, as a surveyor, you should survey the record monuments and the record deed. And if there is an oral boundary line agreement, that should be up to whoever's putting out the affirmative defenses. You can make an affirmative defense in court for these kinds of things, but no, as a surveyor, I may document that agreement by taking some kind of oath from the property owner, tell me all about it, do all this stuff, but I'm not going to change someone's boundary based on an oral agreement.
Oral agreements are completely binding. As long as both parties entered into the agreement and you've got evidence of the agreement from both sides, it's a binding agreement, will be upheld any day in court.
Well, I'm not sure about that, because the statute to prevent frauds requires all real property transfers to be in writing.
That raises a really interesting point. You mentioned the 2 buckets, and you said, I think, title in one and unwritten title in the other. It really isn't quite right. What it is title doctrines in one bucket, boundary law in the other bucket. And boundary law only fixes a boundary. And if you read court cases on boundary agreements, they will all over the place say, yeah, an oral agreement is upheld by the court because it's not a transfer of title. It doesn't transfer title.
Well, the court can make
of the existing boundary and resolves all ambiguity as to its location.
So here's my
title at all.
Here's my issue with that is the court can do that. That's fine. But as a surveyor, I'm not going to move a deeded boundary based on an oral agreement. If
But
they
you,
want to go
but
to,
see, but an oral agreement supersedes the deed.
I
And
don't know
so
about
you're going
that.
to say, well, I will ignore a more important or a higher level of doctrine for a lower level of doctrine because I'm more comfortable down here on stake and deeds. And no, we're not allowed to do that. We can't pick and choose which boundary doctrine we want to hold to. If there's an evidence of an oral agreement and you can gather the evidence and prove, yeah, these two people will say, yeah, we agreed. Here's where our boundary is. That's where the boundary is. I can't change it. I'm not this. I can't say, well, yeah, but your deed says something different, so it's going to control over your agreement. No, that's not the law. The law is that the agreement controls over the written document. And all they've done is establish a location of their boundary that was unknown, uncertain, or in dispute. And they've resolved those ambiguities. There's no exchange of title. They've always owned up to their boundary. They didn't know where their boundary was. They've entered into agreement and said, here it is. And in that kind of a case, I don't redescribe both parcels because the boundary descriptions or the descriptions of the two parcels don't change. The only thing that happens is you insert a document in the record that says, here's the boundary based on other monuments and surveys and ties and new bearings and distances. Here's the boundary. Here's calls to any physical objects along the line. Here's where your boundary has been agreed to be. That doesn't change their legal description. Both parcels stay the same. There's no exchange of title, no exchange of quitclaim deeds or anything like that is required. All it does is says, here's my boundary. Person buys a piece of property, it's subject to that agreement that establishes one location of one boundary. It doesn't change the entire parcel or anything. And that goes back to also the point that Jerry brought up about the 100 and the 100-foot wide parcels. And all of a sudden you got a 99 and a 101. Yeah, stuff happens. And it shouldn't, but it does. But in those situations, there is this overlying principle that what the original record says is correct. It's infallible. Like the original monuments set by a surveyor, they're infallible. But that original record was written by the original parties, was intended to be those words that were laid down on paper. That's infallible. Well, it says it's 100 feet wide. I go out and measure it, and here's two original monuments that are 99.8 feet apart. Because
That's a great point, John. So let me explain that in my desire of evidence school, land surveyors can make some quasi-judicial decisions. So what do I mean by that is, we have doctrines like priority of calls, junior senior rights, follow the footsteps of the surveyor, all these things that we're applying all the time. And that's stage 3. You've got stage 3, which is the interpretation and the final decision making before the survey map and the report gets made. So we are allowed by the rules of evidence certain leeway to make opinions, determinations of boundaries. And that's what it is. It's an opinion based on the facts, how we apply the rules of law, like priority of calls, to the facts, and we form an opinion. But I feel like that the traditional school of thought has a very limited number of rules of evidence to apply. While the contemporary thought is much broader than that. We found that the fence existed for 25 years, therefore we're going to hold the improvements. That's something I wouldn't do in the traditional school of thought.
Yeah, I wouldn't either. It's not, you make it sound like a simple jump. Well, I found the fence 25 years old, so therefore the fence is the boundary, and here's my boundary.
Well, let's make it tougher. Let's say, in Florida, adverse possession requires that you pay taxes on the property, that it does for so many years. It's open, notorious, all these different, checklists. So I feel like the contemporary school would run through that checklist, and if it met all those requirements, they would hold the fence. If I'm wrong, you can tell me, but that's what I got from Jeff's presentation.
Yeah, I wouldn't make the leap to hold the fence. I would say, yeah, I've got all the evidence that says the fence is the boundary. Now the question is, how do we document that? How confident am I in that decision?
Yep.
What's going to be the recourse and those kinds of things? That's all now to be considered before I jump to saying, yeah, they're declaring the fence as the line.
Yep.
And it may be my opinion the fence is the line, but it's not documented yet. And I want to see
Yes.
the documents.
Now, in the contemporary, in the traditional school of thought, I don't think I would ever jump to the fence as the line unless there's some kind of record document that says go north to the fence and then along the fence and then head south again. Ian, you got a question? Jump in, please.
There's Ian.
Yeah, well, I was on the phone on the way home. I'm home now, so I'm on the computer again. One of the things that always comes up, particularly in California surveyors jump in and go, "Oh, boundary line agreement, oh." We have two kinds of things in California: boundary line agreement and a lot line agreement, a lot line adjustment. Boundary line agreement is not a lot line adjustment. A lot line adjustment is a ministerial function by a local jurisdiction that says, yes, we are allowing you to violate the Subdivision Map Act and create this little parcel or parcels that are not allowed to be created on the Subdivision Map Act and convey them to the other person, also not allowed under the Subdivision Map Act, and then merge those into the other parcel, not allowed under the Subdivision Map Act, which is why it's in 66412D, or 66412, which are the exceptions, the allowed exceptions of the Subdivision Map Act. Now, the boundary line adjustment, and other people have said this, and I've heard this recently from other people, oh, you can't, title insurance companies won't insure boundary line agreements. It's a bullshit. They don't know what you're talking about, or you don't know what you're talking about telling them what it is that you think you're talking about, because the boundary line agreement is, we have no effing idea where this boundary line really is. Don has just come in here and opined that it's here, and we think he's full of Utah BS because we think it's here. That's where we want the line. It's the surveyor's job then, in my opinion, to sit back and say, hey guys, thank you very much. We just cut through a case of Opus 1, coming up with this boundary line agreement. Love it. Let me document exactly where it is, and there we go. And one of the things that really pisses off the local jurisdictions is that when you come in with the boundary line agreement, they go, oh, no, we have to review it. No, you don't.
No, you don't.
No, you don't. Shut up, sit down.
Yes.
The boundary line agreement is an agreement between two property owners. Now, as long as it doesn't violate any of the building codes or anything else, they got nothing to say in it. And it really pisses them off because they don't have any money in it. And I'm the county surveyor now. So.
Yes. And, I remember getting ready for the California PLS exam. The top three things, one of the top three things to study was the Subdivision Map Act, because there was the, minor subdivisions and major subdivisions and the planning process and all the exemptions. I think like cemeteries are exempted or something ridiculous.
Well, what it boils down to is the fact that if you're going to subdivide land, there's a whole lot of people going to move into that. And those people are going to build houses and need water and have kids that need to go to schools, and houses that burn down and need fires and shoot each other, so they need police, and they're going to poop and need sewage. And damn it, as the local jurisdiction, I want to make sure that the infrastructure we have in place will serve those people and not deleteriously affect the people who already live here. That's the whole deal about the Subdivision Map Act. And you can carp about it all you want, but it's really a straightforward position that says John and Mary, the beautician and the assistant manager of the Kmart, who are buying this piece of land and building their dream home, don't have to be experts in boundary law or property law to buy their house. They can sit there and go, we bought the house, we built it, it's just wonderful, and not have a problem. That's the whole point of the Subdivision Map Act. It's not to piss people off. And quite honestly, it's the best thing in the world, because as a surveyor, it's a rule book. It's written words that you all, I'm pissed when I was in the private side, I used to piss jurisdictions off by going in and sitting down and saying, okay, subdivision map act says this, your local ordinance says this, and they'd say, I don't know, we'll have to look that up. I said, I already did. This is what it says. Get it done. It's a rule book. You can't break these rules.
Yep. Yeah. And
Tony, there's I believe it's probably, is it you, Summer? It's Zoom user.
Yeah. Hi.
Okay. Yeah, I thought that was you.
Hi. Okay, I do have a few questions, and this is like really, really awesome. I just want to say thank you. We're going through this every day, all day, and I'm in Texas. The issue is like I think question number one is, where is the line drawn between survey and law? Like, where do we say, okay, this is now a attorney's question versus a surveyor question?
That's a great question. And I love Texas because one of my favorite states to practice in, because there's always a complete mess. Like, there's a 150-year-old deed that says, go 1,000 varas to grandma's chicken coop. And that was destroyed 120 years ago. Like, how do I figure this out? Okay, so I don't know how to tell you that, Summer, because, I would say that land surveyors are given some tools in their toolbox, like priority calls, junior senior rights, all these different, tools, where if we find a conflict in evidence, we can resolve it ourselves. So you've got a very limited toolbox. And if you go to the Texas rules, there's actually 5 rules in there: junior senior rights, priority calls, follow the documented evidence, follow in the footsteps of the surveyor. If you can use those 5 or 6 items to solve your inconsistency, you're practicing surveying. If you have to go outside of those rules, you may be practicing law. Or even if you're not practicing law, maybe you're just making a determination inconsistent with whatever toolbox you're given. Like, you're trying to use a screwdriver when you need a hammer, go call an attorney or tell the property owner to deal with it, and you'll help them.
Right. And that's the thing is we've run into situations where it's who calls the attorney. Is it us, or is it the property owner? Is it
it's the property owner?
Yeah. And so that's where we've run into issues when why are we going to call the attorney? It's their issue. And so that's where it's become really difficult, where I'm saying I'm not going to bring in an attorney.
He's not your attorney. He's the property owner's attorney. Yeah. It's going to go, send a letter to the neighbor and say, hey, we have a problem here. It can't be solved by a surveyor. We need to come to some kind of agreement, or I'm going to sue you. And a lot of times when you threaten to sue someone, they come to the table and say, okay, well, let's work it out. And other times they, oh, I wish I had my iPad here. But I've got a funny thing to share with you guys before we leave today. I'm going to make sure I turn that on. Okay, so what's your next question, Summer?
Well, you just actually covered all of them. Okay, actually, Connie had one. The proration and evidence. Okay, and Connie, I really appreciate that. Proration is not always the procedure that's used, and that people really have issues like slop versus proration. Is there a rule that you stand by that makes sense? Because we've had an issue where we have actually misplaced evidence and need to retract that evidence, pull it out of the ground, parade it back out, and we can't get to it. Then it becomes this. That is something I would believe would be a legal issue. So that relationship between proration and existing evidence was really, really meaningful. And so if y'all could help me with that.
Yeah, I mean, proration is very dangerous because proration is a last resort, like an absolute last resort. And imagine if you have like a block in a subdivision and you've lost all the interior monuments. You just have the four corners of the block. If you prorate that, I can almost guarantee you that the prorated monuments, the new monuments you place by proration will be different than the fences and the driveways, or it may be off by a little bit, like a few tenths of a foot, or it may be off by 10 feet. I mean, who knows?
Yeah,
So you got
right.
to be very careful of proration. And the textbook evidence and procedure talks about you've got to go to the best available evidence. So what is the best available evidence? Maybe it could be this intersection, like the center of the street. Maybe it could be other kind of improvements. But just be very careful when placing new monuments by proration, because I think it was the quasi-judicial functions or another paper said when the surveyor shows up, the neighborhood goes to hell. Like, just upsets the
Yeah.
whole apple cart. And they see
It's
the
so true.
surveyor and they're thinking, oh my God, what's going on? I've gotten to the point where I carry armed security with me. Every field survey, there's an armed security guard there because the
Yeah.
neighbors could be super cool about it, or the neighbors could be complete psychos about it. And I've had, an entire neighborhood in their car following me around before.
Yeah, we've
Full
had armed
throttle,
security. We
kill
got
Dr. Nettleman.
cartel. We have, yeah, we got all kinds of crazy stuff going on
Yeah,
here.
all kinds of
Yeah,
crazy stuff. And you never know. Like,
yeah,
you could be in the middle of nowhere, and I almost got hit by a
yeah,
truck one last year
yeah,
doing
yeah,
like drag racing and like this empty road. You have no idea what's going on. Well, when the police
yeah.
officer saw that truck flying down the empty road, he caught him in like 2 seconds and he was in cuffs. So, you know, whenever I have a field survey, I call the local police department. I get a off-duty police officer who's always armed, and you have one of them who watches the equipment. If there's a base station, you have one that follows you around. And this is a funny story. Trent, do you remember Junior? So Trent and I did a survey last year in a subdivision, a nice subdivision in Las Vegas, but you never know who the neighbors will be. So we called the off-duty Las Vegas police, and they said, we have no police officers, we're busy. So we called a private security firm, and I don't handle any of this. I just tell Nate, hey, Nate, get a security guy, have him there for 3 days, like whatever happens. So who shows up but Junior? Junior is like a 6'5", 400-pound black guy in body armor, bulletproof vest, with a huge gun. I'm pretty certain he had an AR-15. I mean, he was just locked and loaded in this completely sleepy upscale subdivision. The neighbors were just driving around thinking, who is this black person in our subdivision, first of all? And why is he wearing body armor? And why does he have a gun? It was the funniest thing. It was great. So Junior got and what's even funnier is the neighbor who we were surveying was like this Chinese couple who didn't speak any English. They had no English whatsoever. So there was just like this giant black guy walking around their backyard, and they had no idea what was going on. It was funny. It was a great laugh. It's been a while, but I still
It's
laugh at
funny until
Junior.
somebody gets shot, right?
Right. Yeah, exactly. Well, Junior is so big and so well armed. I think we would come out on top. If there was any kind just hide behind Junior and we'd all be safe. But yeah, exactly. So, proration is very dangerous. I'd be very careful. I've never used it before, believe it or not, in
We do it
25
all the
years.
time. Okay, that's really interesting. This is huge. This is very interesting. Very, very interesting. Thank you.
Sure. And the funny thing about this presentation is there's no outcome. There's no final answer. This is just meant to get the discussion going between the traditional and the contemporary school of thought. And I have nothing but good things to say about Jeff Lucas. He's a nice guy. I see him a few times. We're always friendly. So I have nothing personally against Jeff. In fact, I like him as a person. I just disagree with some of the doctrines he espouses. And that's why we're here, kind of getting a discussion going. So all I can tell you to do is that the more leeway you take, the more rope you take out, the faster you can hang yourself. So all I do is testify in surveyor negligence cases. Like I do at least a dozen surveyor negligence cases a year. Did they follow the priority calls? Did they follow junior senior rights? Did they search for the monuments? A lot of times it's no, but sometimes I have a case where the surveyor did everything right. Textbook boundary. He gets sued by the developer because the developer built a 0 setback line, and now they think the building is like 0.01 inches on their neighbor's property, so they're being sued. So it doesn't matter how good you practice, you can always be sued. So I just want to learn from the practices, good and bad, from all these people who I'm trying to help or prove negligent, and not do it myself. So what I'm trying to get here is to make smart decisions. And if you feel comfortable, if you think the rules of evidence, the rules of law, the rules of surveying all allow you to do something, go do it. If you're uncomfortable, don't do it. And just be aware that, you've got pillars of information like the state acts, the state rules. Those are like dead set. You need to follow them. You've got other more fuzzy rules, like the Texas board says the surveyor must know and apply all Texas statutory law and common law. So you as a Texas surveyor are expected to know the entire universe of Texas law, starting in 1820 whatever all the way up till today. Well, if you get the fuzzier you get in the rules you're applying, the more dangerous it becomes. So can you defend your boundary determination? Yes or no? How much so? 99%, 95%, 51%. If it's getting below 90%, if you think that another surveyor can legitimately contest your results, then you probably should not be signing that survey. So just think about that. I'm not saying you can't make determinations. You can, you have to every day. You just have to make sure your determinations are within the scope of surveying practice. Does that make sense?
Yes.
Totally. Thank you.
Now I've got to show you guys this picture.
Rob's got one too. Hold on.
Rob, yeah, come on, Rob. Tell us.
Tony, just a quick thing. You mentioned survey reports, and are those reports are they primarily given to the client along with the plat, or
yes,
are they
every time? Yep. Okay. When a client orders a survey, whether it's a boundary relocation, whether it's a riparian allocation, whether it's a question of unwritten rights, like, hey, my neighbor built a fiber optic line 2 feet outside of his boundary. I always give them a map, and it's usually like 5 or 10 or 20 sheets, zoom ups of areas, blow ups of areas. I like to put half the maps with my new aerial. I fly with the airplane or the drone, and the other map without an aerial, so you can see just the line work. So I like to do lots of maps. And then the surveyor report always goes along with the survey map. And it's very specific format. It's an introduction, documents reviewed, thesis questions like what's the issue to solve. And then I go through my 3 steps. What's the record research? What's the field evidence? What's my analysis? Record research, field evidence, analysis, and you go rinse and repeat for every report. Now I could throw in there a 4th step, like I do the upland boundary, I do the riparian allocation, choose my method, then I come to a conclusion. But yes, the client always gets the report, and I always have a bunch of appendices on there too. Every document that's reviewed, it becomes an appendix. Aerial photos, title reports, previous survey maps, previous plats, section data, whatever it is, I make an appendix because there's never been too many appendices in a report.
Okay, and that sounds like something that would come in super handy if you ever had to sit on the witness stand and
Yes,
talk about your survey.
that's right. And my report only has all my opinions. If you want to make a Rule 26 report, which is Rule 26 of the Federal Rules of Evidence, that's what I use as my template. All of my opinions are in the report, at least the best I can. Because when you go sit for a deposition, if you tell the truth, that there's no contradicting yourself. All you do is regurgitate the report. And then when you go to testify in trial, you just sit back and relax and put your feet up on the stand, because you've said all your opinions in the report, you've said all your opinions in the deposition, and now you're just going to say the same exact thing in trial. So if you're just, the report is like an outline for all of your opinions, and you're not going to deviate from them, and you're not going to make any more opinions once the report is done, because that way you can never get contradicted testifying, because all you're doing is regurgitating the report you wrote.
Yeah. And Connie had a great take on proration, if you saw her type comment.
Tell me. Yeah, I didn't see that one.
Oh,
It's up a
okay.
little ways.
I'll talk about it for a second, if I may. So there's a couple of things that I pay attention to when I'm doing proration. Is my proration in a harmony with the rest of the evidence?
Sure,
So,
yeah.
if I'm doing a subdivision and I'm moving hundreds, I'm sure that it's going to be in harmony with the evidence, because I'm not going past what's going to be considered a material discrepancy in the area. I'm just futzing with math. Okay, so in that case, I'm not too worried about it. Secondary is if I also, what I'm looking at is, when I'm doing a proration, am I working within the parameters of my predecessor's precision? Okay, if I'm doing an old subdivision that was pulled with a chain, and I happen to see that the guy had a long chain because the chain was old, and if everything's kind of harmonizing with the rest of the survey, yeah, okay, then it's reasonable for me to think that the evidence will scale up and down with with the precision that he's working on. If we also have maps here where we the mapping convention is, if you have excuse me, if you have a block and the last set of lots in a block is not labeled with a distance, that means that the intention of the block is to put the excess in that last lot instead of prorating it. So I watch for that. Now, if I start having a difference that is of a larger magnitude than that, then I will be digging for more evidence to see if I can explain that, because I do not expect my proration to move lot lines. Let's say I have 1,000-foot subdivision and 100-foot lots. If anything, in something like that, if it was from 1930s, I might be expecting to see a foot at the most. If there's anything more than a foot, or within reason of that underlying surveyor precision, I'm going to look for other evidence to explain why my monuments are moving so much. So I will not just go and move the lot lines 3 or 4 feet just via proration, because that's just, it doesn't make sense. That's not what it's intended for.
And that could really depend on, what is your precision, depend on, where you are. I do a lot of surveying in Miami, Fort Lauderdale, Palm Beach, and 1 square foot could be worth $10,000. So, a tenth of a foot could really matter. And I've had several mid-rises that were built on the setback, on the property line, dead on.
Yeah,
and
0 lot line.
Yeah, 0 lot line. And the neighbor sues because there's a possible 1-inch encroachment, 1 inch. So, but then you have the farms in Texas where, plus or minus, few tenths of a foot, no big deal. So you have to kind of decide, what is the required tolerance from the board acts and the rules, and what is the, issue here? Is it going to be like a $10,000 a square foot issue, or is it going to be like a $5 a square foot issue and the neighbors, call it copacetic?
Mhm.
Tony, before you jump on, two things. Guidelines to writing survey reports. I just threw that in the chat.
Oh,
Martina,
great.
we did that with Gary Kent, week 102. So that's on the website, or YouTube as well. And then back to your conversation a little bit ago about basically telling them to go hire an attorney or something like that, right? I think part of that would be having that network of friends, associated with the state associations or all these different things where you can have other surveyors that you can rely on to ask questions, right? Before you just throw your hands up and go, I can't resolve the boundary. You want to reach out to other friends or colleagues and network with them and ask them to, a cursory review, right? So that way
Yeah.
we can end up more in the John Stahls conversations with mediations and boundary line agreements, as opposed to just throwing your hands up and go hire an attorney and then go spend $75,000, right? So I think those
So
are
yeah, I like that. And Nick says the attorney's only tool seems to file a lawsuit. They will need the surveyor to assist determining the facts. Well, I do agree with that to some extent, but the attorney is the advocate for the property owner. He's representing the property owner. He wants the best for John, the property owner. So the attorney has lots of tools. He can write a letter to the neighbor and say, hey, let's work this out. The attorney can mediate, hire a mediator, all these things. And, the attorneys really, from my experience, do not want to go to court. They'll do just about anything to avoid a trial. Now they'll put on a big show and, puff up and, strut around for a few months and make some money, but they really prefer not going to trial and putting this in the judge's hands. So I like to think of the surveyor as the objective party. We don't work for the property owner. We're getting paid, but we're not working for him. And if there is something that is adverse to the property owner, I tell him right away, like, hey, you think you own this easement, but you don't. I'm in stage 2. I don't think you own this easement. Are you sure you want to go to stage 3 and spend another $25,000? Hey, they can say no. But personally, in my practice, I never work with landowners. I always get hired by the attorney. The attorney signs the contract. The attorney does all the correspondence, because like the landowner, they'll tell you their story back from when they got married in 1962. I talked to an attorney. Hey, I've got a potential encroachment, need this figured out. I'm going to lunch, or no, even better, this was someone last week. I'm going to Europe for 2 weeks. Figure it out and let me know what happens. Okay, no problem. So it's a 2-minute conversation versus a 2-hour, history of the world, according to Jeb the farmer. But anyways, attorneys have a lot of tools in their toolbox. They've got letters, they've got threats, they've got mediation, arbitration, all these things. And I like to get the attorney involved, because if you have one attorney advocating for a neighbor and another advocating for the other neighbor, you've got two parties that know the law, they know some of the facts, they'll get your help on the subject matter, but they're advocating for their own parties. And I feel like the property owners, when it's property owner versus property owner, it's very personal. When it's attorney versus attorney, it's very procedural. They're trying to make some money, they're trying to possibly resolve this, but it's not personal. Like attorneys would never attack each other over, oh, well, you said my boundary was at the tree when I think it's at the stump. The attorneys would never go through that. They're just here, providing a service. And they're going to see the same attorney at dinner at the cocktail hour at the bar association next month. So it's very, it's a little more anesthetic, a little less personal when the attorneys are involved.
Yeah, and
the attorney,
George has a good comment in there too, right?
Yeah,
the
George.
The attorney only has the obligation to the client. The surveyor has a responsibility to the public. So
yes, and I say, the attorney's number one client. They say, is Jeb the farmer your client? And I say no. Well, who's your client? The public of Texas, the public of California, the public of Florida. Now, I may be getting reimbursed for my time by Jeb the farmer, but my client is the public in the state, and I'm not going to give Jeb what he wants to hear because he pays me. I'm going to give Jeb an objective survey. And if he likes it, that's great. He can continue on. If he doesn't like it, he can fire me. I won't be, those kind of clients who will pay you to say things that aren't true or are not the clients you want in the first place. Get rid of them. Gary, Gary did a great talk on the Surveyor's report. Definitely check it out. William says, does your report give the date of the last time your equipment was calibrated? I don't do this all the time, but I should. I usually get a calibration report from the dealer and I attach it to the report as an appendix. Got to get, how can you make a report? How can you make a 50-page, a 500-page report by adding 450 pages of appendices? Yeah. And it may be worth it because, 50 years later, somebody could be reading your report and it may not be directly on point, but I found like 2,000 pages of Palm Beach sectionalized field notes that were unrecorded. They were in the county office, got them all scanned in, attached it to my survey report. Someone's going to be searching for those Palm Beach County section notes one day. They're going to pull up my report, and my report's like 2 gigabytes because it has so many appendices attached to it. But when they find those thousands of pages of section notes that nobody else has, someone's going to thank me for my crazy report links.
Tony, your appendices is the only place those notes are going to show up, because at some point the county's going to change buildings and somebody's going to say,
what is this crap?
What is all this? That's old records. Just throw those out.
Junk. See ya. File 13. Yeah. See you later. And what's crazy is in Palm Beach, the county surveyor was actually destroying original section monuments and putting in his own monuments based on subdivisions, residential subdivisions, for a while. So that's why there's, the most expensive county in Florida has the worst, section data. So that's why I keep all this stuff, because it could be useful later on, when the next boundary dispute, explodes in Palm Beach. But anyways, I've got to share this picture. Trent, can I share my screen with you, please?
Yep, and 5. Good. And then, hey, Will, on the calibration route stuff, I do, if I'm writing an expert witness report, I do say, such and such equipment used on that date with a calibration date of, so I, on an expert witness case though.
Yes. And in the methods section of the report, I put the type of equipment used, like, a Trimble R12i, RTK, GPS, and the field notes have the serial number and the part number and all that stuff connected back. But I was in my Facebook this morning and I saw this. This is hilarious.
Yeah.
A-hole. Oh, man. All right.
So there wasn't any explanation on that either. I was looking at it to see, on my phone to see, all right, is the fence built further to the north than it should be, or, compared to where everybody else is mowing,
That's so funny.
I wasn't sure what the cause of that was.
Oh my Lord. So funny. I really enjoyed the presentation, guys. Thanks for all the questions. There is no answer. You will receive no answer from this presentation. There is no conclusion. The only conclusion is do your own research, make your own decisions, make smart decisions. And like I tell my students, please don't be the one I'm testifying against next week.
Yeah, that's awesome. Will has his hand up there. One more.
Will, yeah, jump in, please.
Yeah, sorry, I just had one more. So on your surveys, do you mark them on your header as a boundary survey or a results of survey?
Well, I mean, I give them in Florida. I like the Florida rules. I like, they used to be better, but got changed a few years ago. But I like that Florida had different categories of surveys, like boundary retracement or riparian allocation or construction survey, whatever. So mostly I do boundary relocations. I do riparian allocation. So I just say, like, what do I think generally, what bucket does this survey type fit in? And I just put it on top, because you can name it whatever you want to. You can call it a forensic retracement. You can call it a boundary retracement. You can call it a boundary relocation, whatever you want.
Right. Well, when I was coming up and I would do all this research and I would pull all these surveys, we got record of survey, result of survey, result of boundary survey, strictly boundary survey.
Yep.
And I asked my boss, and I'm like, what is the difference between all this? And he just said, well, if you find all the corners and everything's good, it's a boundary survey. If you've got pin cushions everywhere, then that's a results of survey. And then they have to pay for the boundary survey if they want to.
That's
so,
funny.
I mean, yeah. And that's the thing, the more
Yep.
evidence, it's not free, and, so it's.
Yes. And I think you can name it whatever you want to. And, in some states like Florida, you had to call it one of 7 categories. And the problem was people were doing they were calling it like a survey sketch. Well, they were calling it a survey sketch because they wanted to avoid the standards of practice required from a boundary survey. So then Florida would say, it doesn't matter what you call your survey, it matters what you did in your survey. So if you relocated boundaries in this survey map, you could call it a sketch, but it's still a boundary survey. So I'd say call it whatever you want to. It doesn't, as long as it makes sense to you and it's clear the purpose, you can call it whatever you want to.
Right. Well, it got brought up in court one time. That's the reason I asked, is because the prosecuting attorney was saying, well, did you set any caps? And I said, no, I didn't set any caps. The lot line is in, we're arguing over it. So I did a results of survey and I recorded it. She goes, well, under the statutes, you recorded a survey and you didn't set monuments. So I had to explain the situation. I said, well, I will set monuments after, our judge.
You're a nice guy, William,
makes a
because
decision, but
yeah, you're a nice guy. I would set the monuments and I would say, this is it. This is the boundary between the neighbors based on the best available evidence. And if you don't like my monuments, disprove them.
yeah, all I did was
pull 'em up.
find original. All I found was original monuments, but that's
Oh,
what
okay.
started the-
That's great.
Yeah.
Yeah. Now, the most fun is when there's 2 different surveyors who have set 2 different, sets of monuments for one boundary. You go to court. The sweetest feeling you'll ever have is winning and then going and pulling his monuments when the judge tells you to.
Luckily, the neighboring survey was he's our president of our chapter, and he was pretty good
okay.
about it. And yeah, we agreed. We both agreed. So
Nick is so cynical. He says the threats, move the old fence to the math. Unfortunately, the attorney will get paid more than us, regardless if they win or lose for the client. Hopefully, they don't get an attorney that struggles to properly interpret the evidence. So I would tell you, Nick, that most attorneys cannot interpret the evidence. They're going to rely on the expert to explain boundary law. Now, the good attorneys will be like students. They'll ask lots of questions. Hey, can I get your books? What does this mean? What does that mean? I've had attorneys tab the books and ask questions. It's amazing. Great people. They want to learn. I've had other attorneys who care less. They say, well, just fix it. Figure it out. Fix it. Tell me the answer. So I've never met a real property attorney before. I've seen them call them real property attorneys. What they are closing agents who close property. I've never met a boundary retracement attorney. So you're the expert. You're the surveyor. You're going to teach the attorney what he needs to know as long as he's willing to listen. And remember, attorneys have boat payments too.
the only one in the courtroom who knows less about surveying than you and the attorney is the judge.
Exactly.
And that's funny because I've had cases where the judge was extremely interested in learning more about boundary retracement, listened attentively, made smart decisions. I mean, so they're students too. And the role of an expert, the role of a surveyor in court is to teach the judge about real property, about boundaries, about surveying. So I start off with the very basics and I work my way from there. If the judge doesn't want to listen, that's fine. They don't have to. But many times the judges are genuinely interested in what the determination is going to be. and you have to make it interesting and fun and informative so the judge enjoys it, sucks it all up, and comes to a proper determination. Connie, you got a question? Okay, I thought you were unmuted. Sorry. We have
had
to
her hand up
instruct
and then-
them. Nice, land surveyor. Yeah, thank you, Luis. Good food for thought. Yeah, exactly. We all have personal and professional boundaries. You do what you feel comfortable. You do what you think is right, and have lots of liability insurance. That's my ending. That's how we're going to conclude this. Have an incredible amount of liability insurance. You know, get an umbrella for like millions and millions. But you either have to have it, you have it two ways. Either you are completely broke and you are completely judgment proof, because I've had plenty of attorneys and clients want to sue a surveyor. They don't bother because the surveyor has nothing of value. So why bother suing? Judgment proof. So either A, you need to be completely judgment proof and completely broke, or B, you need to have yeah, a very, very big umbrella. And that's smart for everybody, personal, professional. My sister-in-law has a daughter who's totaled 4 cars and injured a multitude of people over the past 2 years. They didn't have an umbrella. They're going to lose everything. I've got a huge umbrella, and you know, hopefully none of my kids will be doing crazy in vehicles. But if they do, you've got a, you know, $5-10 million umbrella to protect you. You need a good liability policy for your business, because I've seen even great surveyors who did everything right get sued and go through hell. So it doesn't matter how good a job you do, you got to protect yourself. So lots of insurance, or have nothing, or have a negative net worth. I think I'd choose lots of insurance route, but you can make your, you know, make your choice.
Exactly.
I'm just the surveyor. I haven't reached a positive net worth yet.
That's a good story. Just keep telling everyone that.
Right? I just spend my company's money. They have net worth to worry about.
Perfect. They can pay the insurance.
Right?
All right. Well, it's been a pleasure, guys. I know it's going a little bit later than usual, but
No,
thank
it's good.
you.
That was a great
Enjoyed it, had
conversation.
fun. And maybe you know, we'll get Jeff back in here to, you know, do it again, and we'll have some more fun. But you know, thank
Absolutely.
you, Jeff Lucas, for giving us the opportunity to kind of critique your contemporary thought. Thanks for everybody coming. Had a great time. And I guess we'll see you back on the next Mid-Touring Mondays.
Yep. We'll be back next month. So I love it. Great job, Tony. That was fun.
Thanks,
See you
Tony.
guys.
Bye,
Thanks
everybody.
much.
Have a good week. Bye.
Thanks, Tony.